And thank you, Sally. And thanks, Lauren, for being here and joining us. And thanks, everybody. We've got people dropping in every minute here, so we'll kind of let people filter in. Today, Lauren Case is going to be talking to us about some really critical estate planning issues. This kind of, when we had the idea to do this, it was twofold. One, we had a session before on grief. We're kind of a lot of us are at the age where we are seeing our parents, hit a certain era of their life. And we're seeing, I've had a number of people come talk to me about people whose parents had passed and um, did or did not have good, adequate planning. But then, whether you're in that stage of life or whether you're in a different stage of life, I think this is always important stuff. And I was kind of thinking back on it, and even me as an attorney, when we had our kids, we put some estate planning in place. Who will take care of the kids if my wife and I both die? Who, not just the monetary part of it, but who will raise them? And then we proceeded to not update that paperwork for 20 years. And so when the kids graduated college, I said, oh, we ought to go back and maybe look at updating this paperwork. And it was kind of terrifying to me how bad it was. Because if something had happened in those intervening 10 years, like our paperwork made no sense. So the point is, I think that you need to do this, but you also need to update it. And with that, I'm going to turn it over to Lauren, who's also going to tell us a lot of other important do's and don'ts, and hopefully be able to help you in your planning for both you as well as for your family, the generations above and below you. With that, Lauren, take it away.
Thank you, Glenn. I appreciate it. I'm sharing my screen now. It's loading. Here we go. Can you come here, please?
Yes, of course. It's
okay. Why is it not showing?
What's not showing?
We see it on our end, Lauren.
I can see
You
it.
do?
Yes.
Yeah, we can see
my
it.
computer there. It shows exactly what.
Okay. I'm just making sure you can see it.
Yep.
Okay, so thank you for the introduction, Glenn. I am Lauren Case, for anyone who does not know me, which is probably most of you at this point. And I am an attorney, and I am licensed in both Massachusetts and Rhode Island. So with that said, I am going to caveat this presentation with this is not legal advice. It is only a presentation to give you some information to start thinking about for yourself and for your families. So in my, Tanya, we have the wrong one. Sorry, I apologize. No, that's the wrong one. Bear with me. How do I get out of here? Sally, so much for doing this beforehand.
It wouldn't be real life if there weren't hiccups every once in a while. That's okay.
Yeah.
We are seeing the first of 42 slides where it
Yeah,
says
that's
why
the
you
wrong
need an
one.
estate plan. Okay.
Yeah, so I'm trying to. Is it this one? Yeah, it wouldn't be good. Here we go. Much better. Can you see this?
I am seeing that, yes.
It says estate planning for you, your parents.
And your college kids, yes.
Okay, there we go. Much better. So, Tanya, can you come back here for a second?
Yes, of course.
I just want to make sure that they're not seeing the side thing.
We are. Right now we're seeing the
Right now
side
this-
slides.
So you need to switch it to from beginning.
From beginning.
Yep. There you go.
There we go. I think I'm on board now. Okay, because I was looking at the front page and I'm like, this is not right. It's missing something. Okay, so my why is I have 3 kids, and we have Courtney on the far left, we have Zachary in the middle, and we have Alexandra on the right. When I first joined ECC, Zach was only 9 months old, and he's my youngest, and now he is in college, so I've come a long way from them. So overview, this is going to be what we're doing. We want to make sure that your estate plan documents are up to date. We want to be able to plan for incapacity. We want to minimize taxes and costs of probate administration. You want to make sure that you distribute your assets the way you want to, as opposed to if you don't have a will, the state that you live in will dictate who gets what when you pass away. Also, some people want to be able to support their favorite charities. Last but not least, peace of mind, making sure that you have peace of mind. So in a basic estate plan, you have a last will and testament, durable powers of attorney, designation of guardians if you have minor children, healthcare powers of attorney, a living will, and HIPAA authorizations, and trust. Trusts are always dependent on whether or not a client wants a trust, and there are many different types of trusts depending on the situation. So if you were to pass away without a will, as I previously stated, the state you live in will dictate how your assets will be distributed upon your death. A will is a set of legal documents that is considered a set of instructions to a probate judge as to who you want to manage your estate, who you want to take over as guardians for your children, and where you want your estate to go. So if, for those of you that do have wills in place, are they up to date? So for example, the personal representative you've named, are they still around? Do you still want them to manage things? I find a lot of people who did wills when their kids were very little, they fast forward 20 years, they're in college, and they look at their estate plan, and the person that they named as personal representative might have passed away. A lot of times young adults will name their parents, and then things happen. You know, time has passed. And for your beneficiaries, are the right people receiving the right assets? So just check on your wills. They don't ever expire, but the information in them may not be applicable anymore. Okay,
Gene was like from here to the dump truck long. It took a roll, a 2,000-pound roll.
what was that?
Oh, it's just somebody.
Oh, okay.
You're good. Just keep going.
Okay, so keep going here. I'm going to do this, it'll be easier.
Oh, you just switched it. You
Um,
need to go back to present.
I was trying to get it so I could see if there was any chat things.
Oh, no, I'll let you know. Just from current slide. There you go.
So, when does the will become effective? A will takes effect upon your death. However, it must be approved by the probate court in order to be legally binding. So, I have a couple of things that come in when I'll have clients that come in say, hey, no, mom and dad did not have a will, but I have their power of attorney. Just so you know, powers of attorney expire when the person expires as well. So that's not helpful. And then true or false here, if I have a will, my estate does not need to go through probate proceedings. Again, that is false. Because if you have a will, it's great, it's a set of instructions, but it doesn't, just having a will does not avoid probate. Question I get asked a lot is, does the will create extra expense for the estate? I'm going to say no, because having a will in place, not having a will in place costs more, and not having a will in place makes things take longer in probate. So for example, in Massachusetts, if you don't have a will and you need to sell your heirs need to sell your home when you pass away, they have to do a whole nother step during the probate process in order to sell that house. So you've automatically just tacked on, I'm going to say just filing fees is anywhere from $500 to $1,000 in filing fees, plus you're adding on attorney's fees, so plan on about another $3,000 added on to the probate expense because there was no will. So probate property, what actually goes through probate? What goes through probate is anything that you own when you pass away that's in your sole name. So for example, if you own your home, in your own name and it's not in a trust, that is going to have to go through probate proceedings. Most married couples have owned their home as husband and wife or tenants by the entirety. It's never an issue when the first spouse passes away. It's when the second spouse passes away that the house will need to go through probate. Property held jointly with someone else is usually not probate property. So if you have a joint bank account with your spouse, 99.9% of the time that account will just go to the surviving spouse, or if it's not a spouse, the surviving owner. Again, 99.9% of the time. There are cases where someone else's name is on an account, but it's only as a signatory, and once the person passes away, that goes away as well. So it's important to know how you own your joint assets. So what happens when there is no will? It's called intestate. State law dictates a court-appointed administrator manages your estate. So if you have, I'm going to give you what happens in Massachusetts. You don't have a surviving spouse, but you have adult children. In Massachusetts, all of those adult children would have what we call priority to be appointed by the probate court. Think about, do your adult children all get along? If they don't, you're going to have some issues. Your assets are distributed based on a legal hierarchy, starting with spouses, so usually spouses first and then children. It does get a little bit messier when there are blended families. So one of the things I work a lot with blended families. I enjoy working with blended families. And it's important to make, especially with a blended family, it's really important to make sure you have a will. Because you want to make sure that assets go where the married couple wants them to go. Also, if you don't have a will, the court will choose a guardian for your minor children. So think about that as well. Are there people that you don't want as guardian of your small children? Also, for those of you who don't know, a will is public. So anyone can go to the local probate court and ask for, they can look up the docket number and then ask for a copy of the docket. So there is no privacy in a will, so whatever you put in a will and that you maybe disinherited somebody, that is public knowledge. Also, when someone passes away, if anyone's gone through probate recently with a family member, if there is any real estate involved, you've probably gotten phone calls or letters in the mail, hey, I want to buy your house. That's how they know, because they're looking at the probate records, they're looking at the publications in the newspaper. Now the question, is joint tenancy a good substitute for a will? So the problem with joint tenancy is lack of flexibility, creditor risk, no financial protection, no tax benefits, lack of control, vulnerability. So say I have a joint account with my oldest daughter. That's great if she's a true joint owner with me, because if I pass away, then she'll get the account. She doesn't have to share it with her siblings. The other issue is that if she's a true joint owner, she can withdraw all of those funds. Furthermore, another big issue is that if she runs into problems with, say, her lease agreement or her credit card, that's considered an asset of hers and they could attach it. So joint tenancy is not always a good substitute for a will. Sometimes it's necessary, depends on the situation. The other thing is with anybody who is in the higher income brackets and higher brackets for an estate, if you need to do any type of estate tax planning, you can't do that with a joint tenancy. And then the other thing, simultaneous death. So think of a joint checking account between husband and wife. If they both pass away in a car accident, then that joint asset is going to have to go through probate if there's no beneficiary on it. Life insurance. If you have life insurance, review your beneficiary designations. Always name a contingent beneficiary in addition to the primary beneficiary. And also, life insurance is considered in your gross estate for estate tax purposes. What I'm finding now is a lot of couples in their early 30s, they take out for each of them $1 and $2 million life insurance policy. So in Massachusetts, that's going to put you way above the estate tax exemption amount. So the next item, we have durable powers of attorney. Durable powers of attorney, it designates a trusted person for you to make financial affairs for you during your lifetime. Super important, especially for if anyone has a parent who is older and the other parent has already passed away. If they end up with dementia or Alzheimer's, and they don't have a durable power of attorney in place, yet you need to sell their home in order for them to go into assisted living, you're not going to be able to do that without a proper durable power of attorney in place. I actually had a client during beginning COVID where his mom was in a rehab and he just transferred her right over into the assisted living part of the rehab. After a year and a half, he's like, you know what, I'm going to sell a condo because she's not living there anymore. She's not going to go back. She did not have a durable power of attorney. He could not sell that house, the condo, because he didn't have any authority to do that. So we had to petition the Massachusetts probate court and get him appointed as conservator of her property. So again, this was during COVID, so this took a full year. It cost over $3,000. It meant he had to come into the office. We had to, instead of appearing in court in person, the hearings were by Zoom, but it was just a $200 standalone document would have avoided all of this. So again, if you see your mom or your dad, if you see that they're going down, if they're declining mentally, make sure you have documents in place. Once they have been officially diagnosed with something, these documents cannot be prepared. They can be prepared, but they can't be signed. Is your power of attorney up to date? Is your designated agent still living? Are they still willing to serve? Is this person still who you want to manage your financial affairs? And have you named a successor? My rule of thumb for powers of attorney and healthcare proxies is the document no more than 7 to 10 years old. You should consider doing updates because things change, addresses change, who you want in charge change. Guardianship of minor children. Although we put in our wills who we want to raise our minor children, we can also do contemporaneous documents that say who we want to raise our children if we cannot. And that's super important because it takes time for a will to go through probate. So if you have minor children, you want to make sure that you have that separate document. That way, if something happens to the minor child's parent, the person who is designated as guardian can raise the paper and say, hey, they appointed me to be guardian of this child. So you should be the one who decides who's going to raise your children and not a judge who doesn't know you or your family. So again, going back to short-term guardians, long-term guardians. I just talked about long-term guardians. Short-term guardians, that is you go out on date night and you don't come home and the babysitter calls the police. You don't want your children to inadvertently drop into foster care. So a separate document from the long-term guardian document is a short-term. Who to call in case of an emergency. When you're looking at guardianship of your kids, do you still like the people that you've chosen? Are they still somewhat nearby? Have things changed? Did you anticipate that they would be married to each other and maybe they've divorced? Another important thing is, have you included a medical power of attorney for the minor child? So healthcare powers of attorney and living wills. So a healthcare power of attorney, sometimes we call it a healthcare proxy, is someone to make medical decisions for you if you can't. If you don't have someone appointed, and I don't know if anyone remembers the Terry Schiavo case, probably about 17 years old now when it happened, but she was newly married and she had a very debilitating stroke, and she very little brain function. She was confined to a hospital bed, and she didn't have a healthcare proxy. Her husband wanted to make her comfortable and let her pass away. However, her parents fought it, and it was 10 years through court battles to determine what would happen to her, and they finally took her off life support. A living will is instructions to your healthcare agent as to what your end-of-life wishes are. Many states will also do advanced directives or do advanced directives in lieu of a living will. I personally like living wills because if I am entrusting my healthcare agent to make the best decision for me, I am entrusting that they will also know what I consider quality of life and when it's okay to let me go. And a living will is not the same as a DNR. A DNR is something you sign with your doctor. Again, is your healthcare power of attorney up to date? Is your agent still living and willing to serve? And have you named a backup? HIPAA authorization, it gives access to people, it's appointing certain people the ability to access your medical records. So the example I always give is in my own family. I am my mom's healthcare agent. My brother is backup. My sister is not on there at all because she just would never be able to pull the proverbial plug if my mother needed it. And my mother doesn't want to be hooked up to life support. So a separate HIPAA authorization, it allows myself, my brother, and my sister to talk to doctors, to obtain and review medical records, because in all likelihood, with my siblings being a lot older than I am, they would have the time to do that. I'm just going to make the final decision on, you know, if any healthcare decisions need to be made, and my mother cannot make them. Now we get into trust. A trust is a legal arrangement. It allows a person to hold and manage assets for the benefit of another person. So we call them trustee and beneficiary. A revocable trust is flexible. It can be amended, changed, canceled, revoked at any time during the grantor's lifetime. Irrevocable trust is permanent, and once established, it cannot be changed or revoked by the person who established it. Irrevocable trust, you probably hear them as Medicaid Asset Protection Trust. Those are the types of trusts that people put in place because they want to ensure that a nursing home doesn't get I say that pretty loosely, a nursing home doesn't put a lien on their home if they're on Medicaid. So when to create a trust, and I'm talking specifically here about revocable trust, you maintain privacy, you avoid probate, you control your legacy, and you can reduce taxes, estate taxes. So remember how I said that a will is public record? Trust is not. So if you put your home, so for example, I'm going to give you an example, I'll give you myself as an example. My home, if you go to the Registry of Deeds, you'll see my home is in a trust. The beauty of that is the day after I die, my successor trustee can sell my home, or they can rent it out, they can do whatever they need. They will have, because I have beneficiaries lined up, my beneficiary is my trust, so I have it set that my trustee will have access to all of my funds as trustee, and she can dole out money to my 3 kids as she sees fit, or by the age designations that I've set forth. So I've said, you know, age 25 they can have half, age 30, they can have the other half. But she can control that, so she can pay for college, she can pay for a down payment on a house. She's stepping into my shoes as the financial parent. So we're talking about my sister, who is my successor trustee. And nobody, it's not public knowledge. It stays within the family. It doesn't go through probate. And if I were married, I would have extra clauses in there to manage estate taxes. Let's see, so with a revocable trust, you are in complete control. You can also set up your revocable trust to provide asset protection for your beneficiaries or from potential spouses that they might have. You can control your assets. I call it revocable trust. I call it controlling from the grave. So basically with my trust, I am controlling when my kids get it, and so at what ages, under what circumstances. If anyone has any type of addiction issues, my trustee has authority to step back and not do that. So an estate tax. Okay, I have a question here. To place a house in the trust, the deed must be renamed. Correct. That is absolutely correct. Estate tax is a tax on the value of assets that you own at your death. So estate tax is everything you own at your death, including life insurance policies, 401ks, everything. So the exemption amount for 2025 is $13.99 million. If you pass away with more than $13.99 million in 2025, the exemption, the estate tax will be 40%. This is federal. At the end of this year, unless Congress takes action, it's sunset, so we're supposed to be going back to about 6.2 million is 5.4 million adjusted for inflation. With the Trump administration, I really think they're going to extend it. So estate taxes in other states. So I have on here California, Colorado, New Jersey, and Texas. Let's see. So for people living in these states, you do not have a state tax. You just don't have one when you die. Unlike Massachusetts. In Massachusetts, we can pass away with up to $2 million. And after that, everything above $2 million is going to be taxed. And it's going to be anywhere from 7.2% to 16%. So for anyone in Massachusetts, plan on roughly 10%. I had one client, I remember distinctly, she was bummed, not unhappy, but bummed that she had to write a check out to the Commonwealth of Massachusetts for her mom's estate for $99,000. This is back when the estate tax exemption was only $1 million. So I was just told that the question was asked, what are the downsides of using a trust? It's more expensive than just doing a basic estate plan with a will. However, I call that pay me now or pay me later, because it's still a lot less expensive to do an estate plan with a trust, so you avoid probate, than it is to go through probate. Going back to estate taxes in Mass, for those of you in Massachusetts, this is federal as well. There's an unlimited marital deduction. Spouses can leave everything to each other estate tax free. The issue becomes when the second spouse passes away, then everything above the $2 million will be there'll be an estate tax on it. So property included in the gross estate for estate tax purposes is assets with a beneficiary. Jointly owned property. Remember how we said jointly owned property, if it's a true joint ownership of, say, a checking account between a husband and wife, that will avoid probate. However, half of that property is in the deceased estate for estate taxes. So, I'm going to kind of wrap this up. With your parents, durable powers of attorney. If you only get one document in place for your parents, have it be a durable power of attorney. Healthcare powers of attorney should have. And if a blended family, wills are definitely a must, and a trust is highly recommended. With a trust, you really, especially with blended family, you really want to keep conflict to a minimum if you can and keep it out of the probate courts. I really don't see a downside to a trust other than I have had clients come in, they're like, you know what, I want a trust, and then if I find out that they have a very simple family situation and there is no real estate involved, and unless there's, that's when I'll say you don't need a trust. So sometimes it's just really simple, there is no need for a trust. If a parent is the guardian of another person, obtain coded guardianship through the probate courts. So I've had a couple of situations where, actually one situation in particular, mom and dad were guardians of their adult child, Sam. Her name is Samantha, and she has Downs. Dad had passed away, so what we did is we petitioned the probate court in Massachusetts to have Sam's younger sister, also an adult, be appointed as a co-guardian with mom. Glad we did that because it was a real fluke, but mom passed away unexpectedly at age 61. So what was good about that is that Sam's sister, Rachel, was able to step right in as guardian of Sam, so that Sam was not in limbo without any type of guardian in place. So for yourselves, if you have minor children, make sure you have guardianship nomination. We all hope that people will step up and want to take care of our children if something happens to us. That's great, but are there people who you don't want to be guardian of your minor children, number one? And number two, are family members going to fight over them? So make it clear. Durable powers of attorney, definitely a must. Healthcare power of attorney, a must. And a trust, a must if you have minor children. So, what are the downsides to okay, so how does the trust impact property tax breaks? For instance, state aid, residents over 65, It depends. It's going to depend on your state and it's going to depend on your municipality. And yes, Glenn, you're absolutely right. Federal rules differ on estates left to non-U.S. citizens. With that, with the non-U.S. citizen spouse, think of it this way. We call it, I've had to set up a trust like that before for clients. We call it a qualified domestic, it's called a QDOT. It's a qualified domestic trust. And the government wants to make sure they get paid their taxes. So taxes will have to be paid up front from the non-U.S. citizen, because otherwise the non-U.S. citizen could go back to their home country and avoid estate taxes. So there really is, yeah, so you have to be cognizant of those things as well. So kids age 18 and older, healthcare powers of attorney are a must. If your child who's 18 now, number one, you can't talk to the doctors anymore. You probably can't make appointments for them. You want to make sure before they go to college or trade school, or even if they're still around, you want to make sure there's a healthcare power of attorney in place for them. And they should be able to name who they want first, mom or dad. It's usually, sometimes they might name somebody else. It's important because if mom and dad disagree, say there's a car accident, if mom and dad disagree about what could be done, they're going to end up in court. Actually, I'm going to go back real quick on that one. Also, with the healthcare powers of attorney, I had friends of mine, this was years ago, twin daughters went to Kansas to college. One of them got really, really sick. They could not get any information over the phone from the doctors, even though mom was an orthopedic surgeon here in Massachusetts at Children's Hospital. Dad ended up having to drop everything, fly out to Kansas, be able to get there to actually talk to doctors in person and explain who he was. I mean, it was a lot of rigmarole where a healthcare power of attorney in place would have sufficed. So, any questions? So I can go back to, I'm looking to see, Tanya, I don't know how to get to the chat.
So you can unshare your screen. And I'll do mine.
Unshare?
Or you can just, I can do mine. You
Okay,
can,
what am I doing? Okay,
you can just close it.
can close this out.
Now you're showing everything too. You're good.
I'm good. I don't see anything. Okay,
Lauren,
so
Lauren, I had one question. This is Glenn. So
Sure.
I'm kind of in that same boat, right? Like my youngest just turned 18.
Yep.
My older daughter, when she turned 18 2 years ago, I did absolutely nothing. Is there like I mean, I know it might differ, maybe it differs state by state, maybe it doesn't, but is there a link or a direction that you would send us for like draft HIPAA waivers or FERPA waivers, or, what else would you need for your kid who just turned 18, who, as a parent, you think you have access to their issues and then suddenly legally you don't?
Right. So durable powers of attorney and healthcare proxies. I am finding some colleges actually have their own healthcare and power of attorney forms that they want filled out. So if a college has that, use the college one first. If not, you can even get your state's forms. Each state has like their boilerplate healthcare proxy or power of attorney form that you can use. It's just the key of getting it notarized and or witnessed properly. Does that answer your question?
Yep, super helpful.
Okay. Any other questions?
Mike has his hand up.
Yeah, hey,
Mike
Mike
Bolton.
Bolby here. Good afternoon, and thank you again for the information. We're right in the middle of all of this stuff, so the timing was impeccable. What are your thoughts on using like Ethos, LegalZoom, Trust and Will, some of these online platforms, that are 500 to $1,000 to kind of set up estate planning, and they have access to attorneys for additional fees. Just overall, any words of caution using that versus local attorneys, or what are your thoughts?
So when it comes to the online things, for example, someone asked me to review their trust document, and it was the Suze Orman, is that what it is? Okay, so these people are in Massachusetts, but it said California law would apply. So each state has different rules, and you want to make sure that the rules are proper. The problem with the online stuff, it doesn't take into, yes, they ask you questions, but it doesn't take into effect each family's specific situation. So I really caution you on that. As far as the prepaid medical plans, they are at such a, people pay very little for those, sorry, the legal plans, people pay very little for those on a monthly basis. And I had looked into like being part of MetLife Legal's plan a number of years ago, and it was like, I can't do that for this cost. So if I can't do that for that small cost as a newly practicing private attorney, what quality are you going to get?
Gotcha. No, makes sense. Hey, thank you so much.
Absolutely.
Rich, go ahead. I see your hand up.
Oh, Lauren, good to see you, by the way. Long time
Thank
no
you.
see. Hey, so given your definitions of the revocable and irrevocable trust, it doesn't make, in what circumstances would you ever use an irrevocable trust? That's my question.
So I find irrevocable trust, with an irrevocable trust, you're giving your home away at a certain point in time, that date being the day you die, right? So I find it appropriate for clients that they've worked hard all their lives, but they really only have their home that's really the only asset they have to give to their kids. So they want to protect the home. There is no mortgage because you have to be very careful that if you don't want to put a home into an irrevocable trust if there's a mortgage on it, because if you read your mortgage document, there's a due on sale clause. If a bank finds out you did that, they could call in the rest of the mortgage and you have 30 days to pay it. Also, you know what? These clients, they intend to be carried out in a pine box. So that's usually my criteria for an irrevocable trust. I find most people they're kind of in the middle between, they have other assets, so they have liquid assets they would never be able to spend down enough to be even to qualify for Medicaid. And then for clients that, I'm thinking of one in general, one lady in particular, she wanted to put her home into an irrevocable trust. Her husband had passed away. They never had kids. And I asked her, I said, she wanted to make sure her house was left to her nieces and nephews. And I said, that's well and good, but if something happens to you and you get sick, you've given your home away and you blow through the rest of your liquid assets, you're going to be in a dumpy nursing home because you're in a Medicaid bed. Number one, do you really want that? Do you really think a niece or a nephew are going to step up to the plate and take care of you? So in that case, I usually try to steer the client away from putting their home into an irrevocable trust. I'd rather they have that home available. So if they need to go into assisted living or a nursing home, they can sell that home and go to a nice place. She and her husband worked hard for that. I want them to go into a nice place. Oh, and going back to the irrevocable trust part, you also have to be in pretty good health because there's a 5-year look-back period for Medicaid purposes. Does that help, Rich?
Yeah, no, thank you. And if I could have one follow on, besides a home, what kind of assets are typically put into a trust? Over?
So, some people know that they're going to be up against the estate tax when they pass away. They will create what is known as an irrevocable life insurance trust. And that's a trust where they put essentially a life insurance policy, but it's there specifically to pay for the estate taxes. You don't ever want to put any potential liquid assets that you have into an irrevocable trust unless you absolutely positively know you don't need those funds. If you are, I don't know, say, so for example, I have an 89-year-old client who is adamant that he needs all $3 million to live on for the rest of his life. Realistically, it's his comfort zone and it's his prerogative, but he could easily put $1 million into an irrevocable trust, and if he makes a certain amount of time, that won't be included in the estate. But if he dies anytime soon, then he's going to have an estate tax problem in Massachusetts.
I think he was asking what you can put into a revocable trust.
Oh, revocable trust?
Yes, yes.
Oh,
What
other
type
assets?
of things
Okay.
are,
Okay, other things that are revoked. Tanya just clarified that for me. Other assets. Think about if you have minor children. Minor kids cannot inherit money. So you could put liquid assets into a revocable trust. You could, for example, my life insurance policy and my other investment accounts have named my trust as a beneficiary, or I could have just put them, the trust could own it as well. So I can put those assets into a revocable trust as well. Anything that has a beneficiary designation. People do vacation homes. Some people will put boats in their trust. It depends. It's very dependent on the specific situation.
thank you.
Welcome.
Lauren, I have a question. What if my 18-year-old mistakenly signs two durable powers of attorney, one with me and one with my ex-husband? Like, what
Okay.
then? Is it the one that is signed sooner, like more recent,
Yes.
or oh, the one that's more recent is the
Correct.
prevailing document?
Correct.
Okay. Thank you.
You're welcome.
Right. Looks like we just got a chat in with a question. Is there a difference between living revocable trust and revocable trust?
Great question, and there is no difference. Sometimes you'll hear a living trust, a living revocable trust, revocable trust. They all mean the same thing. It's just it's a moving document. You can amend it, you can change it, and it's for you during your lifetime.
Thank you. Anybody else have any other questions? I don't see any more in the chat, but if you want to come off mute or put them in the chat, feel free. Erin, yes.
Hi, Lauren. Thank you. We're a military family, so do you recommend our legal forms be where we reside or where our home of record is?
Oh, that's a good one. It's going to depend on, so wherever if you reside, what state do you live in right now?
We're in North Carolina, but our home of record is Texas.
Okay, so I think this is a situation dependent, but if you're worried about estate taxes, you want to execute those documents in Texas because there is no estate tax in Texas. If estate tax is a non-issue, just get them done in North Carolina. Is as long as, so for example, then say you were to move up to Massachusetts, other states will recognize documents done in a different state provided they were executed in accordance with that state's laws. So for example, Rhode Island, remember I said I was licensed in Mass and Rhode Island. In Rhode Island, certain documents do not need to have witnesses on it, just a notary. In Massachusetts, certain documents need a witnesses too, and a notary. So as long as I executed the documents properly in the state where I executed them, the other state will accept those documents.
Okay. Thank you.
You're welcome.
All right. I'm not seeing any other questions come through, but Lauren, thank you very much. I'm sure we all appreciate this. We've got lots of people in the comments who have sent in their thanks for sharing this information. Very important for all of us to keep in mind. And we have your contact details. I sent it out with this invitation, but I'll be sure to send out to the entire group how to get onto your website or how to reach out to you if they do have some more questions they'd like answered.
Sally, Gwen, thank you very much for having me. I appreciate it.
Yeah, thank you very much. We really
Okay.
appreciate
Yeah,
your time and
absolutely.
this
Thank
info.
you for your time. Yeah, it's fantastic. Appreciate it.
Okay, have a great
Yeah.
afternoon, guys.
You too. Tiffany, I see your hand raised though.
One more question. Yep.
No, no, sorry, no, sorry, no. Bye, Lauren, I miss you.
Hi,
Bye,
Tiffany.
Lauren, I miss you.
Take care.
Bye, Lauren. Good to see you.
Bye.
Thanks so much, Lauren.
Thank you.
Thank you, Lauren.
Thank you.